Hello, I'm Kim Walker from Shakespeare Martineau, the UK law firm, which is the Privacy Rules member law firm for the UK, which was, of course, until last Friday evening, a member of the European Union. This briefing is to look at the effects this huge event for the UK will have on the processing of personal data in the UK. We're at present in the first week of the transition period. This lasts under the withdrawal agreement, which the UK has agreed with the EU until the 31st December this year, so 11 months, which is a relatively short period. During that time, the UK and the EU will try to negotiate the trade deal and all the other arrangements which will need to be put in place theoretically by the time of the end of the transition period. The transition period can be extended under the withdrawal agreement by agreement between the UK and the EU once for an extra 1 or 2 years. However, the UK government has categorically stated that it has no intention at all of extending the transition period, which it prefers to call the implementation period, beyond the 31st December 2020. So we're going to have a very busy 11 months ahead. The main effect of the transition period is that during it, EU law continues to apply. Although the UK is not technically a member state of the EU anymore, for the purposes of the transition period, it's treated for most purposes as being a member state. So EU law remains directly effective in the UK, and that of course includes the GDPR. So the GDPR, as we know and love it at the moment, continues to apply in the UK, whether it relates to UK personal data or the data of citizens outside the UK and the rest of the EU. So if you complied with the GDPR last year, you will be continuing to comply this year. If you were in breach last year, you'll be in breach this year, and the same sanctions and penalties will apply. The UK's supervisory authority, the ICO, the Information Commissioner's Office, will remain the lead supervisory authority under the GDPR for businesses with cross-border processing whose main establishment is in the UK. So the EU's one-stop shop regime will continue to apply. The only change is that the ICO is no longer a member of the European Data Protection Board and can attend their meetings by invitation only and has no vote. At the end of the transition period, the ICO will cease to be a competent authority, so it won't be able to be the lead supervisory body anymore for the businesses which process data cross-border with their main establishment in the UK. So businesses will need to start thinking before the end of the transition period, if they trade and process data across the EU, whether there are any other EU member states where they can say they have a main establishment and can nominate their lead supervisory authority and so continue to benefit from the EU's and the GDPR's one-stop shop. Likewise, UK businesses which process data cross-border but don't have a main establishment in the rest of Europe or in the EU outside the UK will need to think about appointing an EU representative